So I want to remind everybody that we are recording, and I want to welcome everybody to ADA Webinar Part 3, the process of self-disclosure for students with disabilities. And our presenter today is Mr. Diego Demaya. He is an attorney and also the Director of Technical Assistance for the Southwest ADA Center. So at this time, we are going to unmute Marissa, and let me see if we can, and she is unmuted. And Marissa, go ahead.
Hi there. Thanks for having us again, Anne Marie and the folks there at Train PD. Want to just say very quickly, my name is Marissa Demaya, and I am with the Southwest ADA Center here in Houston. We are actually one of 10 centers. Just a little bit of brief background on us for those who did not join before. We're one of 10 centers across the U.S. that is federally funded to provide information and resources and guidance on the Americans with Disabilities Act for consumers and businesses and entities throughout the United States. We are one of 10 regions, and what we cover is we cover a 5-state region, the Southwest region, which is Texas, Louisiana, New Mexico, Oklahoma, and the state of Arkansas. So if you, we'll be, toting the 1-800 number throughout our session. It'll be there at the end as well. If you do call that number, please keep in mind your call is confidential, and you will get to speak with Diego, myself, or some other persons that man the lines here and provide information on the ADA and your rights under the ADA. Again, we want to just reiterate that we're a neutral party. So we don't make decisions for you. We provide you with good information so that you can make an informed decision about whatever the situation is. Without further ado, I'm going to turn it over to one of my favorite people, Diego Demaya. As Anne-Marie mentioned, he's an attorney. He is the lead technical assistance provider and trainer for our organization. Diego, take it away.
Thank you very much, Marissa and Anne-Marie. Good job to both of you. Thank you for being great hosts and getting everybody lined up to listen to this and to participate. I know that this is all very, very technical, and if I had to do it by myself, I probably couldn't do it. And, I used to be in radio a long time ago, and I used to, I'm looking at my computer right now and how are we doing this, how we are on the air, as it were, because we really are on the air live. And I've gotten over my stage fright and all of that a long time ago, but it's kind of strange not having a turntable so I can spin vinyl as I'm talking to you guys, but I think I just gave away my age. But nevertheless, we are going to talk about something slightly different today. We're going to talk about the process of disclosure, people who disclose having a disability, usually to request an ADA reasonable accommodation. And for those of you who may not remember, ADA means Americans with Disabilities Act, okay? And so I'm going to go through a couple of brief reviews in the next coming slides. I believe now we're going to go to the learning outline slide, where I kind of like organized this so we'd have an organized set of thoughts about what we're talking about today. And so we're going to talk about who is protected. Again, that's going to be just a brief reminder from the previous two sessions. Who's protected, who can request accommodations. And then we're going to talk about, student disclosure and who's obligated, who isn't, when. And then we're going to talk a little bit about documentation, because I always get a lot of questions here at the ADA Center. We all do. All of our technical assistance providers get questions about, what is documentation of a disability exactly? There's a lot of confusion about that out there, both from the part of schools, whether we talk about public school or, K through 12, or we're talking about post-secondary education, or adult literacy programs or adult vocational training programs. And then whether we're talking about the employment sector, requesting employment-related accommodations, work-related accommodations. And there's always questions about what's in the documentation. So we're going to go over that in some pretty good detail, I think. And of course, you'll have that in this PowerPoint to refer to back later, or you can always call us. And incidentally, I want to plug in the fact that when you call our 800 number, or whether you send us an email, like Marissa said, they are confidential. They're kept confidential. We don't talk to your bosses. We don't release information. We don't report to anyone. We don't even report to the government, in terms of the kinds of issues that we deal with. We collect and assess our own data. We create our own, studies of patterns and things that we see, which allows us to create, relevant publications, that basically get with the times, like what's happening today, what are the, some of the more salient issues or happenings that are going on with the ADA. So when you call us, you will always get to talk to an ADA specialist. It may or may not be an attorney necessarily, although in the Southwest region, we are lucky to have 3 attorneys on staff that busily provide technical assistance. But I want you to understand that we don't provide legal advice. We don't do legal advice. And what that means very simply is that we're not going to tell you what to do or which one is better or which one is worse. What we're going to do is show you what it means. We're going to isolate the issue. We're going to talk about the facts of what happened or what's involved. And then we're going to show you what the law says. And then we'll show you what kind of options might be available in terms of remedying a situation that might have arisen. And as an attorney, I can tell you that this has been, for the past 15 years or so that I've been doing this for the ADA Center, this has been a true learning experience in terms of becoming a good lawyer, because to me, a good lawyer doesn't, they don't tell people what to do, their clients what to do. They give them options that have viability, options that come with, the what ifs behind them to better assist the person make their own determination, their own decision. And and then we're going to talk about, on this learning outline, we are going to do a brief pass over on dealing with service animals, because we get a lot of questions about service animals. They never stop coming in from all sorts and walks of life. We get questions about service animals and people who want to come into a public place with a service animal. And then lastly, least but not last, as it were, we'll talk about defenses once again in terms of what do you do, how do you analyze the situation if you have to decline providing an accommodation or if you have to exclude a person from participation. Next slide we're going to go to. So who is protected? Of course, you might recall the ADA protects individuals or the rights of individuals who have disabilities, and a person has a disability when he or she has a physical or mental impairment that substantially limits one or more major life activities. Now remember that people only need to show proof or mention at least one disability and one major life activity that's being affected. They don't have to go into the list of other major life activities that might be affected. And I mention this because in the employment sector, that comes up a lot, where a lot of employers, and also in the education sectors, they believe that just disclosing just a little bit about a disability may not be enough. And under the ADA regulations, particularly after the ADA Amendments Act of 2004, essentially all the person has to show is that they have at least one functional limitation that is connected to the disability, And just for your information, a functional limitation, I want people to make sure that they understand what that is. A functional limitation is caused by a medical condition or a disability. Okay, what could that possibly be? I'll give you some pretty straightforward examples. Someone who's blind, the functional limitation is not being able to see. Okay, so you need to think in those terms when you're looking at the functional limitations that will need to be accommodated when someone comes to a class and makes a request for an accommodation. So there has to be a connection. There must be a connection between the person's disability, and the requested accommodation. So the accommodation has to service the functional limitations. I know this all sounds kind of crazy, but there will be a quiz at the end, and I'm going to have you remember everything I'm telling you. And I'm just kidding. But essentially, bottom line is there has to be a nexus, a connection between the disability and the accommodations being, requested. So the next slide, we're on slide 9. What does qualified mean? There's that, qualified, a person is qualified regardless of whether they have a disability or not, meaning that they are qualified to participate in an adult literacy program. So if you were to get someone who signs up to take an adult literacy class, but it turns out that their developmental or cognitive disability is to such an extent that really they're not going to benefit from the program. In other words, they have such a significant learning impediment that essentially they may not be qualified to participate in the program. So you see, they could have disabilities and they can request all the accommodations they want. Extra time, longer testing times, a person to read out loud to them. There could be many things that they really might qualify for to get as accommodations, but then if the person doesn't pass the course or doesn't have the necessary qualifications, eligibility criteria to join the program, to participate in the program, then they're not going to be qualified. They will not be otherwise qualified to participate in the program. I wanted to make that clear because a lot of times services and accommodations are denied under different grounds. And the different grounds could be something like they thought the student was dangerous, or they thought the student was too depressed to participate, or there could be a host of other reasons. And really, sometimes what it boils down to is that they're not qualified because they may not be able to muster the necessary skills that they need to participate in the class. And believe me, this comes up a lot, particularly in post-secondary education, where I have run into situations for people that I've helped and worked with, both at the universities, who work for the universities, as well as students, situations where a student essentially is, out of pity, is allowed to keep attending classes while they keep failing the class over and over and over again. I've met students that have failed courses 3 or 4 times in a row. We're talking, 2 or 3 years in a row, where they fail certain types of courses like advanced math courses, or the first level of college algebra, or they fail linguistic courses, like English grammar course, English Composition 1 courses at the, from the first year. And it's important to understand that somebody has to be on the lookout in the education program. Whether it's the counselor or the intake person, the people who register students to attend classes, they have to be on the lookout. Unfortunately, they have to wear more than one hat. They have to be on the lookout to make sure that they do meet the eligibility criteria to be in the program. But again, don't think that just because they disclose a disability, they're not going to be eligible, or that you need to question their eligibility. What I'm simply getting at is that once they start participating, you need to realize that the teacher may start uncovering other issues for which there may not be accommodations. Okay, moving on. So again, we keep reviewing a little bit. We got, reasonable accommodations. Obviously, I believe that by now everyone out there knows that their adult literacy program has to reasonably accommodate students who come in and request accommodations. I think that's pretty simple and straightforward, so I'm not going to linger on this. We're going to move on to the next slide. The next slide is about preferences for auxiliary aids and services, and I focused on auxiliary aids and services because remember, a reasonable accommodation to request to install an automated door opener is not like a reasonable accommodation request for an auxiliary aid or service which relates to a communication disability. Okay? So remember, auxiliary aids and services, communication disabilities. People who are deaf, people who are hard of hearing, people who are blind or visually impaired, people who have speech impediments, people who might have other sensory impairments that prevent them from communicating, then they typically have needs for auxiliary aids and services as accommodations, which of course could include a sign language interpreter. It could include live closed captioning in the classroom. It could include the use of adaptive devices for a blind person to be able to read, a digital book, for example. Okay, so the thing about preferences for auxiliary aids and services is that basically I want people to understand that they should always engage with the student making their request, engage in an interactive process, and have an open discussion about what it is that they want as an accommodation. In other words, listen to their preference. And then from there, you start determining whether their preferences are reasonable and viable, in relation to what the programs can afford and what the programs can do to reasonably accommodate the student, okay? And remember, we're going to talk about this later on when we talk about undue burden and the fundamental alteration defenses later on. Slide, another review slide, slide 12, appropriate, not best accommodations. This brings into focus the idea that, or the principle, I guess you could say, that people with disabilities are entitled to appropriate accommodations. They're not entitled under the law to best accommodations, okay? The law says appropriate accommodations. And what that means is basically that while they may not get the Rolls-Royce version of an accommodation that they prefer, they might be able to get an appropriate accommodation that still achieves the same goal in relation to their disability, or as I like to say, consistent with their disability, okay? So what you're looking at there is really important because a lot of institutions and education programs, they work under the belief that the law forces them to provide the best possible accommodation, and that puts them in a financial, problem because they may not be able to afford the best possible accommodation, but they might be able to afford an appropriate accommodation much, much better. I'll give you a quick example without getting into any illustrations, but just verbally give you an example. We often have a question that relates to what is the difference between a certified American Sign Language interpreter versus a qualified American Sign Language interpreter. The law says that the entity will provide a qualified, quote unquote, a qualified sign language interpreter. It does not say that the entity has to provide a certified, quote unquote, sign language interpreter. Now, this is really getting really technical, okay? In reality, what you're going to find when you start researching sign language interpreters is that I'm going to guess that at least 70, 80% of them are certified. They're certified by the school they attended, the training they got. They might even be certified by a state agency. In Texas, for example, courtroom legal interpreters, who interpret for people who are deaf and they work in the courtroom, they have to be certified by the Texas court legal system. I don't recall the exact details of who does that, which agency takes care of it, but essentially they have to be certified before they can set foot in a courtroom and translate or interpret for a person who is deaf, who is participating in some kind of legal proceeding in court. Okay. In some other states, there could be more types of certifications. You could have, for example, sign language interpreters who have been certified to do medical interpretation. So they work with doctors in hospitals and clinics and so forth. So that gives you kind of an idea. So the law says that they have to provide a qualified interpreter, right? So essentially what this means is that if there were a situation where the entity cannot afford to pay for a sign language interpreter, they might be able to afford the lower fee of a qualified interpreter. And the regulations and the guidances available from the Department of Justice actually give you some really good guidance on how to determine whether a person is indeed qualified to interpret for a deaf individual who communicates through sign language, American Sign Language. Okay, so we're going to move on to the next slide. So we go to our next segment, the student obligation to disclose. So as we take a deep breath, essentially what you have here is that the student is indeed obligated to disclose a disability if they want to request an accommodation to participate in class. Okay? Remember, why would they ask for an accommodation? It's because that's what's going to allow them to have equal participation in the classroom, whether it is a communication disability or merely widening an entrance door so the person can come through it using a wheelchair. What the person is seeking is equal participation and a level playing field that allows them to participate fairly in the classroom and have the same level of opportunities that anybody else sitting in that classroom has. Okay, so this is what this is about. Essentially, if you were to find out as a teacher that a person has a disability but they're not requesting an accommodation, do you need to accommodate them? Are you obligated? No. You're not obligated to accommodate, even if you see that the person, might be struggling. Now, that's the legal, technical, it is what it is sort of outlook, okay? But for practical purposes and to prevent any kind of animosity or liability, if you do notice that someone likely has a disability, whether hidden or obvious, and you notice that they are struggling in the classroom, then make it a point to approach them and ask if they're having any difficulties and whether you may be of assistance to them in some way. You don't have to say you have a disability or I notice you have a disability or that, you're not understanding the material because you're asking questions that are not relevant or whatever. You don't have to embarrass the person. All you got to do is just simply say, I noticed that you might be having some difficulty, and is there anything that we can do to help you? At that point, you've opened the door. If they don't disclose a disability, well, then they don't disclose a disability. And that pretty much allows you to move on. If they failed the course at that point, then they failed because they failed. They didn't, pass the material. Because, you have to assume that you didn't see any disability, you didn't see any, in other words, you can't just, isolate them in any way. You have to treat them like you treat anybody else, and therefore all applicable grading policies and standards would apply to that individual just like it does to everybody else in the classroom. So I'm just hoping that's, let's see here. Oh, yeah. So if the student does open up and wants to disclose a disability and request accommodations, I would recommend that you hold the discussion in private wherever possible. If it's not possible to have office time to go, that the student can come and talk to you in private, then certainly talk about it, in the classroom, like say either before or after class. Typically after class would be the best time because that's when people actually leave and there's no one around to listen. What you're trying to do is keep as much confidentiality and privacy as possible so that the student is not unnecessarily embarrassed in any way, especially if you might realize that they're not terribly experienced at dealing with their disability, or maybe they're newly disabled. Maybe they just had something happen and now they have a disability to deal with. So I recommend privacy at all times, if and when possible. If not possible, then at least find a quiet corner somewhere to be away from people so that you can talk to the person and try to figure out what it is that they're looking for. The next slide, slide 14, no obligation to accommodate. This is fairly straightforward and simple, but I want to mention it because people have asked us about this. And that is that, again, you don't have an obligation to accommodate if there's no request. And, again, I emphasize this because a lot of people might feel like they're doing the right thing by stepping forward and mentioning, hey, you're having, some issues. All I'm saying is basically be careful how you approach this. And like I said earlier, just say that, I notice you might be having difficulties. May I be of assistance to you? And that opens the door. We go to slide 15 and we go to our next segment. And now we're going to get to some of the nitty-gritty stuff that we want to talk about today. And this is documentation and policy. So what you're seeing here, the first thing is that the student can indeed be required to provide reasonable documentation from an appropriate licensed professional when they make an ADA request for an accommodation and they have a hidden disability or a disability that is not obvious, that you cannot see, okay? I think you know what I mean by obvious. An obvious disability is a blind person, a person who is deaf, a person using a wheelchair. Those are typically obvious disabilities you can readily observe. And from those individuals, the ADA pretty much says, no, you're not entitled to documentation to document that. These are obvious disabilities. And, some people have asked me, well, what if they're faking it? I've actually gotten questions like that. We do here at the center, like we said earlier, your call to us is entirely confidential. Therefore, you may ask whatever you wish. You may say whatever you wish about anyone. It's not going to matter to us. What we're going to look at is what the issue is and what the facts are, and then we're going to try to give you, as helpful as possible information about the question. So, so essentially, reasonable, appropriate documentation. The documentation has to come from a person who treats the type of condition or disability that is being disclosed, okay? And this is important to keep in mind because individuals have been known to bring notes from doctors and licensed professionals that when you look at it in detail, closely, you'll notice that they don't practice in the area that relates to the disability disclosed, and that can either be funny or you'll notice that as an irony. And basically, what this does is it's a yellow flag, and it allows you to ask follow-up questions concerning the documentation, because you actually could say you are within your purview to inquire and say, okay, this is from this documentation came from a licensed, nurse medical practitioner, but you have a disability that says you have dyslexia, how is this person qualified to diagnose your dyslexia disability? So you could ask that question. You could ask them to explain. So let me see here. If we go to the next slide, I want you to remember, this is really important. While the documentation has to come from an appropriate licensed professional, again, meaning that the person practices in the area that relates to the disability. So individuals that disclose emotional disorders, anxiety disorders, for example, might be seeing a psychiatrist, they might be seeing a psychologist, they might be seeing even a social worker for that matter. These are all licensed professionals that practice a particular science and work directly with people. So again, you can scrutinize and see what field they're in and in relation to the disability being disclosed.
I do have
Yes.
a question that came in.
Sure.
We have a stopping point in a few slides. I don't know if you want to take it now or if you want to wait.
No, I'll take it now. Go ahead.
Okay. So the question is, isn't documentation for an obvious disability that might affect the GED testing process, is that still required for the testing?
I think I missed the first part of what you said. Can you repeat it?
Sure. They're asking, isn't documentation for an obvious disability that may affect the GED testing process, is that still required for the testing?
I'm going to say yes. And the reason I'm going to say yes is because of the fact that the entities that test or that facilitate or organize these widespread examinations, whether it's for GED or other types of certifications. Regrettably, these entities are, and I'm going to be critical now, are sort of behind the times when it comes to the requirement of documentation. And the example that I love to use about this is where the Law School Admissions Council, the LSAC, essentially finally, about 5 or 6 years ago, they finally got sued by the Department of Justice because essentially what they did is they kept requesting volumes and volumes of medical documentation from a single individual, essentially basically getting to see their entire medical history, their entire medical record, when really what they were asking was for an extended testing time because maybe they had an anxiety disorder that created an attention deficit disorder, or they were visually impaired and they needed twice the amount of regular testing time. In other words, rather than getting the documentation they needed that related to the request, they would just ask for everything across the board. And they finally got sued. And the other reason why they got sued is because of this exact question, is because they were asking for documentation for obvious disabilities, like a totally blind person, which is kind of a redundancy in words, by the way. I mean, totally blind. I mean, if you're blind, you're blind. You cannot see, okay? There is no visual acuity. There might be light perception when you measure, when you use the measurements that ophthalmologists use to measure eyesight, but it's blindness. They cannot read, they can't see, they can't drive. They might detect light, but that's about the extent of it. So, obvious disabilities like that don't typically require documentation. Again, they're observable. You can see the disability. But regrettably, when it comes to these testing programs, which are run by these larger organizations, including government entities or some of the large, nonprofit testing organizations like ETS, which handles, I believe, the SAT test, as well as, I believe, the MCAT examination for medical school and so on, they're just behind the times, and they just request documentation. They have all these forms. I have not seen any of those forms be shorter than 10 to 12 pages in length, requesting information. And a lot of them are so egregiously in violation of the ADA, But the problem is what happened to the students that were taking the LSAT test to go to law school, and essentially the LSAC would win every single case because nobody challenged them in any serious fashion, or even if the student had an attorney, they would end up in a settlement, in a closed-door settlement, which didn't fix the problem for everybody else, only for the single individual. And so finally the Department of Justice went after them, and they ended up fining them in excess of $6 million. They had to return a bunch of money to a lot of people who took tests. And I mention this example again because the question just asked is a great question. And I want you to know that, no, it's basically wrong to request documentation for somebody who's using a wheelchair, okay? It's very unusual. At least we've never experienced this at the ADA Center. It's very unusual to learn that a person using a wheelchair was basically faking it. It's highly unusual that that ever occurs. I'm sure it has happened once or twice, but it's unusual. You know, people are typically very serious about their disabilities, and they're not about to be joking about it or faking anything about it. If they use a wheelchair, that's because they're paralyzed in some way or another, or they can't use their limbs in some other way. So I hope that answer helps, but basically they will have to provide documentation, and they can try to keep it limited and as reasonable as possible, that in relation to the requested accommodations that they want from the GED testing entity. So what I would tell students, or people that are helping students get the accommodations for their GED, is that they are entitled to make sure that when the doctor fills out the form, that the doctor puts in only the relevant information. I always tell people that they have to control the medical information that goes out of the doctor's office. No matter what the reason or purpose why the medical information is going out, whatever the reason is, people need to be able to control that information, and you can. All you got to do is either be there when the forms get completed, or you can call the doctor's secretary and say, I just want you to limit the information to what is being asked, and don't release for example, what medications I take, because they're not relevant to my need to test, to my need for additional testing time. What does a medication have to do with that at all? Now, if the medication, for example, if the medication indeed is causing a problem, like drowsiness of some sort, obviously that's going to play into the type of accommodations necessary. But again, think about it. People, for the most part, that request accommodations tend to be fairly rational, and they tend to be fairly logical about what they want and why they want a particular accommodation. So, again, you have to try to stick to relevant information. Okay.
Okay, we have a couple more questions that came in. So the GED, just to clarify, Diego, the GED can still request it and deny an accommodation. And if they do that, what is the student's recourse to file a complaint?
Well, obviously, if they're denying a requested accommodation, despite there being an obvious disability that necessitates the accommodation, they're not going to have much recourse left other than available legal remedies through the ADA. So they'll be able to file a complaint with the Department of Justice against the testing entity, regardless of whether it's a Title III, a nonprofit testing entity, or whether it's a government agency facilitating the testing. So either way, they always have recourse to file the Department of Justice complaints, but those are impractical, right? So what I always recommend that people do is to write back to the testing entity, basically as an appeal. You write up an appeal, and you explain that you feel that they are incorrect in their determination, and that, again, here's the medical documentation and why I need the accommodation are requested. So you basically prove it. You show the medical documentation all over again. You attach it to your new appeal application, and you send it off again, and then see whether they're willing to appeal it. In many cases, they change their minds and they turn things around. Sometimes they don't. So unfortunately, if they don't, then the only choices available are going to be either filing the complaint with the Department of Justice, as well as filing the complaint with the Title II entity if they get, if it's a Title II entity. And then people will also have, for both Titles II and Title III of the ADA, they also have a private course of action available to them where they can either by themselves, basically threaten to sue them in federal court, or they can retain an attorney and file a lawsuit against the testing entity, which is what happened with the Law School Admissions Council. It became so egregious and so big as a class action, so many people complaining, that finally the DOJ said enough is enough, and they went after it, and they got them to make changes. And recently, they got on the news again because they started doing it again. They went back to their old habits again. So this keeps happening, folks, and unfortunately, I wish I could give you a golden answer, but there really isn't one. The best approach is to encourage the individual to not give up, to be persistent, to be stubborn, and to just keep filing the appeals until something gives, until they change their minds, until they come up with a compromise of some sort. Now, a quick note on this, and then we'll move on. I often tell people that call us with testing accommodation problems, students. I often tell them that, from time to time, it might be a good idea for them to compromise on the accommodations they want. Sometimes the testing service basically doesn't want to provide 3 times the amount of testing time. They think that's just too much. Or they might even defend themselves by saying that it's a fundamental alteration of the test. We talked all about fundamental alteration in the past 2 sessions. There's an example where the entity can claim that it would be a fundamental alteration to give someone 3 times the amount of testing time. And they feel that maybe, they look on their records, and what they do is they'll do a comparison, which, by the way, they're not supposed to do, but they'll do a comparison and say, well, we've given most blind people just twice the amount of time. That's what we've given them. And that's otherwise known as pigeonholing somebody with a disability. Basically, you put them on the same category as all other visually impaired or blind people. And I always tell them that that's not what the law requires. It's inconsistent with the ADA and Section 504, and that each requested accommodation, even in the lawsuit filed by DOJ, each requested accommodation must be treated on an individualized basis. They must be treated individually. In other words, pursuant to that person's needs. Okay, so let me move on.
Okay, Diego,
yes.
Before we move on, and I think maybe we can wait to ask this question in a few slides.
Sure.
This person's been asked this question a while back, so let's go ahead and hold it. We're on slide 17, and then in a few slides we'll go back and answer that question about what we're talking about right now, okay?
Okay.
All right.
So we're looking at the slide 17, we're looking at the essentially the contents of the documentation, what you can expect to see in a letter, starting from slide 16, and I believe now we're landing on slide 17. You can see the different things that you can expect to see in the documentation. One caveat that I always tell people about is that make sure that you understand that not all doctors or licensed professionals are going to necessarily know what types of accommodations go with what types of disabilities, okay? So the licensed professional that is certifying the existence of a disability, they don't have to necessarily know what accommodations must be provided. A lot of them are not in the accommodation business. They're not occupational or behavioral type of professionals. They simply know how to treat certain medical conditions or certain psychiatric or mental health conditions. Others might be, psychoanalysts, and they deal with anxiety disorders or phobias. But, they don't know what accommodations the person might need. And this is why the law says you have to consider the preferences of the individual making the request. So you see the connection there. But this comes back to the doctor's note in that don't expect to see a list of suggested accommodations. Seldom will you see such a list in a doctor certification. If you do see one, typically it's there because the doctor probably saw the job description for an employment request, or the doctor, consulted with the patient and got more information, and the doctor felt that it was appropriate to mention that the patient prefers, X, Y, and Z following accommodations, and so they might list it in their certification to make it more legitimate or more accurate. And that's fine. They can do that. But again, don't expect these licensed professionals to be professionals at knowing what kind of accommodations. You always have to rely on the request being made by the individual. Okay, next slide. And we have an illustration.
All right. So John, a student with a broken leg in a cast, asks the teacher to reserve the first seat by the entrance door to the classroom to avoid having to navigate around the chairs and tables in the classroom. John has a mobility disability that is typically expected to last no more than 6 to 8 weeks. His request is a reasonable temporary accommodation covered by the ADA. Documentation is unnecessary because the physical impairment is readily observable.
So again, I kind of want to make a quick, little joke here that, we've all seen movies where people just love to fake, having a broken leg or a broken limb or a broken arm, broken wrist, because they're trying to avoid doing something. And it's always funny when we see it in the movies, but really, in reality, I don't think I've ever met anyone or heard or dealt with anyone who actually did it on purpose just to go get an accommodation from their school or to get an employment-related accommodation or exemption from having to do something. And so again, you see why there's no need for documentation here. Okay, the person shows up with a cast in their leg, and they're saying, "Hey, can I reserve the first seat here? Can you help me with, make sure it stays empty so I can sit in it when I come in?" Because obviously it's going to be difficult for the person to walk around in crutches, and you certainly don't want them tripping and falling and hurting themselves all over again. So pretty obvious situation where you do not need medical documentation. Next slide.
Okay, we're at illustration 2. After disclosing to the teacher that he suffers from attention deficit disorder, Barry brings a note from his general practice doctor that states that he is diagnosed with ADD and that he takes an ADD medication to help with concentration. Barry asks for a quiet room and additional time to take exams. While the GP doctor may not be the appropriate licensed professional to diagnose ADD, the letter may be appropriate if the GP based his opinion on Barry's medical file that contains a diagnostic report from a licensed psychologist specializing in ADD disorders.
So isn't this illustration great? This is when we're actually give you the answer, you can certainly question the letter that came from a GP when it relates to something like attention deficit disorder, because you might tend to wonder, well, since when do medical practitioners, general family practice doctors, deal with or practice medicine in the attention deficit disorder realm? And, you might think, it doesn't seem very likely, so you need to question where the information is really coming from. But keep in mind that many many general practitioners, MDs, make it pretty much a habit, a routine. It's a routine for them to prescribe medications that do not necessarily relate to their overall practice of medicine. So, for example, many people get prescriptions from their GP for their psychiatric disorder. Well, why would that be? How would that be rational or legitimate? It's easy. It's because the patient brought a letter into the file from their psychiatrist. So you see how that would occur. Or rather, the psychiatrist sent the letter to the GP so that the GP can go ahead and order the prescriptions without, any doubts that the patient is recommended or advised to take certain, medications. So you see where this comes into play, where when you're looking at a doctor's letter or any letter from any type of licensed professional, you certainly are within your purview to scrutinize this closely and to figure out what's on the letter, what you're being told about the person, whether or not it's relevant to the requested accommodations. And if it's not relevant to the requested accommodations, but you still get enough information to provide the accommodation, that's great. I mean, you can keep the letter, put it in the confidential, accommodations file, and no need to worry any further. But just keep in mind that because there might be extra information there, you have to be careful that that doesn't come into any kind of conversation or disclosure, because you don't want to be violating the person's right to privacy, to medical information privacy and confidentiality. And I'm not going to get into, whether or not the HIPAA law applies or some other type of college or post-secondary education law applies in terms of protected health information. All you need to worry about is that the more relevant and specific the information is to the requested accommodation, the better off you are, the less liability you face as an institution or as an entity providing an educational program. Okay? So just keep that in mind.
Okay, Diego, we are almost at 3 o'clock, so this is the 30-minute warning here. I know we've got quite a bit to get through still, but we have 2 questions in the queue.
Okay.
The first one is, what if part of their disability is obvious, but the part they're requesting accommodations for is not obvious?
Well, you use the same principles. Essentially, question what the letter, or rather, let me put it this way. It would be helpful for you to explain that you need documentation for that aspect of the accommodation, for the aspect that relates to a hidden disability or disability that is not obvious. And you're allowed to say that, by the way. You're allowed to point this out to the individual, again, preferably in a private setting, okay? You're certainly allowed to point this out and say, look, I understand that you have this disability, which is obvious, but you're asking for an accommodation that relates to your learning disability, and that's not an obvious disability, so I'd like to have some, I'd like to request that you bring in some documentation from an appropriate licensed person that can certify that you have this particular learning disability. In the meantime, you would, of course, try to facilitate whatever possible accommodations might be feasible, so the person is not waiting or, suffering, not being able to do what they need to do. So yes, you may actually end up having to grant the double testing time accommodation, even while medical documentation has yet not been brought in. But understand that the ADA requires that. And let me take you guys back for just one moment. In the prior sessions, I forget which one, I actually mentioned that after the ADA Amendments Act came into play, one major change was that the entity is obligated to act in good faith and to reasonably accommodate the person as quickly as possible, even if documentation is not available. Okay? So in other words, making a person wait because they have not brought in the documentation and they might be failing their quizzes or exams is a really bad thing. You should not be allowing that. If all they requested was the additional testing time, which obviously, in most cases is not a fundamental alteration, is not an undue burden, then you need to provide that accommodation to this individual. And you can say, listen, we're going to temporarily provide you with these accommodations, but we still need you to bring the documentation as soon as possible. And you give them a deadline, you give them a window, and you say, can you please try to bring this in within the next 2 weeks? And then you move on from there. Okay.
Okay, Diego, I think we're going to hold off on our next question. We're going to move on because we've got a lot to get through still.
Okay. So we're going to go into service animals. I think that we can get to this pretty quickly. I just want people to... Yeah, slide 21. We go into service animals. I want people to understand that there are certain rules and principles that you must abide by when you're dealing with individuals who are accompanied by a service animal, typically a dog. So I'm not going to talk about this in any particular order. You can look at the slides, but I'm going to mention a couple of things. First is that the ADA has a specific definition for a service animal. Essentially, it can either be a dog or a miniature horse. And I know what you're all thinking, a miniature horse? Like, really? And the answer is yes. The regulations provide that it can either be a dog or a miniature horse. If you've never seen a miniature horse, just go on YouTube. I don't recommend doing it now, but go on YouTube and do a search for miniature horse, and you'll find a couple of videos. They're actually interesting to look at, very interesting. It literally does look like a miniature horse from another planet. And people apparently raise these animals, and they turn them into service animals in some cases, but we have seldom seen one. We've gotten 1 or 2 calls in the past couple of years concerning miniature horses and where they're allowed to go. And basically, the regulations provide that as far as a miniature horse is concerned, they may not be able to enter everywhere the public gets to go. That's unlike a dog. A dog, a service dog, gets to go wherever the public is allowed to enter. Okay? Exceptions to that, we are talking about surgical units, intensive care units, operating rooms, highly protective environments where they deal with chemicals and so forth. In other words, neither a service dog nor a miniature horse will be allowed in those types of environments because they have legitimate contamination and or harm or risk, rational reasons. Okay, so really important. It can only be a dog. Okay, so typically you're dealing with a person who comes in with a dog, and the ADA does not prescribe, it does not dictate what kind of dog, big, small, medium-sized, or breed. Okay, we've gotten questions about people using Great Danes as service animals. Okay, if you can imagine, Great Danes can be, pretty large, we've seen that as a service animal before. We've heard about it. We haven't seen it, but we heard about it. We've also heard people have fully ADA protected service dogs that are little tiny little doggies, that you might even be carrying in a little basket, Well, if the doggy detects a person's seizure disorder, then they are a protected ADA dog that needs to be allowed to come in with the person wherever the public is allowed to go, including a classroom. So the next slide, you actually have the definition of a service animal, what they do. And I think that pretty much went over this, so you understand. You can always refer back to this if you're not sure. This is the actual definition of a service dog. I mean, I quoted it practically verbatim from the Department of Justice guidance, which you can easily find either by Googling, service animals in the ADA, or you can just go to ada.gov. Okay, next slide. Service animals are working animals. They're not pets. I understand that there's a strong urge to use, what's your pet's name? And, you could actually ask the two permissible questions. Is this dog necessary because of a disability, and what does the dog do for you? But understand that they are not pets, and that's what makes them different, that they are working animals. So typically, they're going to have a harness, a leash. They're going to be under full control of the handler, the owner. And yes, they may be carried by the person if there's a small enough dog. But again, once you ask the two permissible questions, let's see, am I on the slide for that?
Now, Diego, we're on, what is a service animal continued?
Right. Okay, so basically, one more thing to mention here on this slide is that emotional support dogs, or dogs that provide companionship, are not protected under the ADA. Okay? It is important to make the distinction. Now, there isn't exactly a clearly laid out definition for an emotional support dog or a companion animal or dog. Okay? The difference is that, again, the ADA does provide a definition for a service dog, and so the dog you're looking for when you're asking the permissible questions, if you go to the next slide, let's see, slide 24, what can you ask? Okay? If you can see the questions here, when you ask those two questions, you're going to be getting enough information to help you make a subjective determination. I want you to understand, I want everyone to understand that this is not an objective analysis, unlike when you're looking at a doctor's note from a person that relates to their disability and requested accommodation. That's more of an objective review of the letter, so you can determine the connection between one thing and the other, okay, the disability and the accommodation. But when you're asking questions about an ADA protected service dog or service animal, you cannot require medical documentation. So let me repeat that. You cannot require medical documentation. You cannot require that the animal be certified in any way. You cannot require that the animal or that the person show proof that the animal was trained by a school or a specialized environment. In other words, the definition of an ADA protected service animal is one that was individually trained. Those are the two key words that tell you what to expect. They were individually trained to perform a particular task for that individual, such as being a guide dog for a blind person, a hearing dog for a deaf person, or a seizure detection dog for a person that has epilepsy disorder. Okay? A lot of times the dog actually comes with these skills built in, such as detecting a person's seizure disorder or an oncoming incident or event of a seizure. Okay, moving on to the next slide.
Yeah, we're about 10 minutes after 3, Diego, so just a quick reminder.
I'm going to try to get through this, right? Thank you. So, again, you can refer back to those slides. So we got rules on service animals. The dogs have to be harnessed, leashed, tethered. They have to be under the control of the handler. Notice the example I put in this slide. I'm on slide 25. Notice the example toward the bottom of the slide there where I mentioned that just because someone is allergic to dogs does not mean that the person with the dog gets to be excluded or told they can't come in with the dog. Okay? You're going to have to make a good faith effort, meaning a good effort to try to accommodate both individuals, because allergies can also be disabilities. They can be deadly to people. People have died from peanut allergies. Okay, so that's just one example. I could come up with many others, but basically allergies could be disabilities if they substantially limit a major life activity. Well, if it limits the person's ability to be in the same room with somebody with a dog, then they have a disability as well. Okay. you're not going to be requesting documentation about the matter, but in all likelihood, you will need to consider the situation and figure out how to best separate these two individuals, these two parties. The restaurant example I used to use, basically, I had the management basically put the people at opposite ends of the restaurant, and that should be enough to prevent the possible risk. Okay, obviously the individuals will have a preference, and they're going to be vocal about their preference, and eventually you may end up having to make a judgment call. You may have to make a decision where you may have to ask one of the two people to possibly join or come in during a different scheduled class. Okay, that might become necessary, and the reason would be that, for example, if you have a classroom that is really small and you have a person allergic to dogs and a person with a guide dog, you're going to probably have a problem. There will be a conflict, and something has to give. And the way that I recommend it, that people deal with this, is on a first come, first served basis, because that's just being fair. And basically, if the person with the guide dog came first into the classroom, they registered first or whatever, then you might want to consider asking the person with the allergy to please join a different scheduled class. Will it be discriminatory to do that? Possibly. I mean, technically you could say that it's discriminatory, that you are asking to segregate someone, or you're asking them to voluntarily segregate themselves, actually. But how viable would that be of an issue in court? I mean, how would a judge look at it? And really a judge would look at it in very likely the same way. They would look to see who came first. They would look to see the overall aspects of the facility, how big, how small, and so on and so forth, and basically that one person will have to be accommodated and the other one will have to be asked to come in at a different time. So there's no easy answer for this fact pattern. Next slide. So again, you can you can ask that a person with a service dog, who comes in and creates a nuisance, you can actually ask them to please remove the dog, and they're welcome to come back without the dog. It's as simple as that, folks. Don't be afraid to look at a situation where a dog, comes with foul odors and nobody can breathe, or the owner of a dog is abusing the animal in public in front of other people. As an entity hosting a class full of people, you do not have to put up with those kinds of behavior. That's not acceptable in terms of social, etiquette. It is unacceptable, and you can certainly ask the person to remove the dog, and you can tell them to come back without the dog if they want to participate in the classroom. And you can tell them why. I would recommend doing it in private if possible. I would always recommend to avoid contacting the police to have somebody removed or escorted out. At all times, try to take care of the problem directly yourselves. Try to fix the situation right then and there, and keep it amicable as much as you can. If it becomes necessary to call a police officer, then you need to certainly do that, and the police officer will act based on what they see. That's whatever is happening. There's no way to know how police officers will react to ADA-related conflicts, so just keep that in mind. Next slide.
All right, Diego, it's your 15-minute warning.
Good. Okay. We have an illustration.
Right. All right. A student comes to class carrying his small dog in a basket. When the teacher inquires whether the dog is necessary due to a disability, the student responds angrily, telling the teacher this is none of her business, that this is an ADA protected dog and she should be allowed to bring it to class.
If we go to the next slide, what do? You ask the two permissible service dog questions that we had in the previous slide. Is this a dog necessary because of a disability? And what does the dog do for you? Okay. If the person doesn't want to cooperate, then you don't have much of a choice except to say, I'm sorry, but you're going to have to remove the dog, and you're welcome to come back without your dog. There is no other way to fix the situation. If people refuse to cooperate and discuss the type of service animal they have and what the animal does for them, then they don't want to discuss it. You can't force them to discuss it. But unfortunately, that means that you don't have to protect them either. You don't have to protect the service dog. You don't have an obligation because the person is refusing to cooperate. So in a situation like this, what I recommend is, since you cannot request medical documentation, right? Nor can you request that the dog is certified or not. All you can do is basically keep as much documentation in your personal log or personal files as possible. So if you're a teacher, you need to go and report the incident to your administrator and make sure they take really good notes in terms of what happened and how it was handled. The dates, preferably the names of people involved, so on and so forth. Okay? You want to keep good records because you want to show what happened, because if the person decides to file a complaint, they're going to say that they were discriminated against and they're going to give their version of the facts. Well, you need to make sure that as an education entity, you need to have your version of the facts clearly laid out when you need to look at them, okay, when you need to refer to them as a defense. Okay, next slide.
Okay, we are running out of time, but very quickly, we did have a question about clarifying, if the dog offers support for someone who has PTSD, do they have to have the diagnosis of PTSD, which states that, the dog helps the vet stay calm, for example?
Well, basically what you have here, PTSD is actually mentioned in the Department of Justice guidance. I don't recall exactly if it's mentioned in the regulation itself, but it is mentioned in the Department of Justice guidance on service dogs, and it is a protected disability that may be allowed to be accompanied by a service dog. So medical documentation, typically no. You cannot request that they bring you medical documentation. This is one of those rare instances where a hidden disability the person has a hidden disability, and you're going to have to presume that the person is being truthful, about their legitimate disability and why they need the dog. And then I also want to mention that in the state of Texas, PTSD dogs are specifically protected under Texas law, and they are allowed to accompany the individual into any public place where the public is allowed to enter. So now we move on to the next one. And that's other question.
We're
no
good to
questions
go.
in? Okay.
Nope. Let's keep going.
So the next slide is undue burden. I'm going to just very, very briefly gloss over this. We've gone over the undue burden defense in the previous two sessions. I think people by this time, if you've been in these sessions before, you know what this is about. I've given you as much detail as I can fit in these slides without, forcing you to read a textbook on these defenses of undue burden and fundamental alterations. The next slide is the factors, for considering undue burden. Okay. As you can see, it's a lengthy list of factors to consider. Slide 33 is asking if we have any more questions, but let me ask you to please hold your questions so we can finish this entire presentation. Slide 34 is basically fundamental alterations. Again, we went over this. And we have illustration 4.
That a student ambulating on a manual wheelchair reports to an adult literacy program director or coordinator that the facility where the AEL class is held has an access ramp leading to the front entrance that is too steep for her to maneuver safely. Now, she's afraid to tip over backwards when she uses it. She also reports she is not strong enough to manually wheel herself to the top of the ramp. Now, measurement of the ramp indicates that it has a rise not greater than 3 inches with a slope that is not greater than 1 inch per every 8 inches of distance. This is consistent with the ADA readily achievable barrier removal standards applicable to existing facilities. Therefore, while the ramp is compliant with ADA architectural accessibility standards, the student may nevertheless require assistance to wheel herself up the ramp.
Okay, so if we go quickly to the next slide, I'm showing you the resolution to think about this type of fact situation, okay, which does occur. I think that you need to understand that if the ramp is indeed compliant, then what is the student asking for? If the student is asking for, actually, in the fact pattern I provided you, she's not saying anything about wanting someone to help her up the ramp when she goes up the ramp, okay, to push her wheelchair. So notice that what kind of a service would that be if she were to ask the teacher or the people facilitating the class to help her go up and down this ramp? That essentially would amount to a personal service. And neither Title II entities nor Title III entities are obligated to provide personal or personalized services as reasonable accommodations. Another example of that would be a student who comes in for class, maybe they're a quadriplegic and they require personal care attendance to go to the bathroom, okay? The school has no obligation, or the education program has no obligation to provide a personal care attendant or someone to help them go to the bathroom, okay? Again, that is a personal service, and the student should be encouraged to get their own personal care attendant, make other arrangements basically to help them with that. And with the ramp situation, the same thing. Now, what would happen if the ramp had not been compliant? Then what was the obligation of the education program? And you can probably guess, yes, they would have to offer the student assistance to go up and down the ramp so she doesn't hurt herself doing it. To prevent the harm, if anything, is why you would do that. And yes, you would have to make arrangements to make sure that the assistance would be readily available when the student is scheduled to show up for class. Okay, and yes, this would require some pretty good involvement on the part of the people providing the accommodation itself, the physical action, the physical accommodation, the assistance that she needs, in that you may have to exchange, for example, telephone numbers, cell phone numbers, so that when she arrives, she calls the person and the person knows to come out and offer the assistance, or provide the assistance. So I hope that people understand, the difference there, where the personal service all of a sudden became a reasonable accommodation if the ramp had been non-compliant. And the other requirement, of course, the follow-up requirement, apart from providing the physical accommodation, would be that the entity would need to go into planning mode and determine the soonest possible time they could modify the ramp and make it safe, more safely accessible. Okay. And again, remember, there's defenses for architectural barrier removal as well, that if it's technically infeasible, meaning that the landscape doesn't permit a longer ramp with a lesser slope, then the entity has to use that defense and decline to make the changes based on those rational reasons. Okay. Okay. We have come to the conclusion.
Just a quick reminder, if you do have any other questions, please feel free to submit them there in that chat area. I did want to go back very quickly, Diego.
Yes.
So just to clarify, and I may have missed this in our discussion just now, does the entity have the right to request documentation from the person about the PTSD for the dog that provides assistance with it? Did we clarify that?
Yes, but let me repeat something. Let me differentiate so it's better understood. If the person with the PTSD comes in and requests a classroom-related reasonable accommodation to participate in the classroom. In other words, to do the work, take the exams, participate in the classroom. Okay.
With
it
their
relates. It right. It relates. No. A person with PTSD. Sorry.
Okay.
A person with PTSD requests accommodations. Let's say he requests or she requests extended testing time because the PTSD gives them an attention deficit problem. It ruins it alters their concentration ability. So they want twice the amount of time on the test. Okay. Notice how that request is not related to any service dog. That's just relating to doing the class work. In that situation, yes, you would be entitled to request medical documentation that shows the existence of the functional limitation that is the loss of concentration because of the PTSD. Okay? And that's how you would show that the accommodation is legitimately connected to the requested accommodation. If, on the other hand, the person comes in with PTSD, discloses having PTSD, and says, I'm going to be coming in with my PTSD dog, that accommodation does not relate to the classroom work. It does relate to in-class participation because it will keep the person calm or do whatever functions the dog will do for the person with PTSD, such as preventing an anxiety attack. Okay? So, but unfortunately, under Title III of the ADA, and ADA protected service dogs, then you would not be entitled to that reasonable documentation. And this is because the ADA dog is protected under a separate regulation, under a separate guidance, and is treated separately because it relates to a personal service that the dog provides for this single individual. So I hope that kind of clarifies the difference between the two. Okay?
Okay. And next, going back to earlier discussions, can a testing service only provide certain accommodations even if it's not in line with the disability? That is, if we can ask this, the GED only has certain accommodations regardless of the disability.
Okay. Huge problem. The entity facilitating the GED is entirely wrong. They are acting in a manner inconsistent with the ADA. In other words, they're violating the ADA regulation. And I'm sorry, but someone's going to have to tell them that. Someone's going to have to make that case to them and say, you guys are violating the ADA because you cannot impose a list of pigeonholed accommodations on a grid, okay? In other words, if you're blind, you only get time and a half accommodations. That does not go. That is unacceptable, and it violates the ADA. The reason is because no blind person will take examinations the same way. To assume otherwise is really short-sighted and foolish. I mean, it just doesn't go. It's irrational. The reason is because blind people, and I'm picking on blind people, by the way, because I'm visually impaired myself, but I know this example really well. Blind people who have no eyesight, okay, they will never take exams the same way. They might have certain similarities in how they study and how they take exams, but they might use different devices. Some blind people prefer Braille. Other blind people prefer using audio devices, like myself. I don't read Braille, for instance, but I prefer an audio version of the test, somebody reading it out loud, or allowing me to use my digital reader so that my digital reader can read it to me on my device. So you see, my accommodation request is going to be different than somebody who just wants to use Braille.
Diego,
totally different. Yes.
I think that we got some clarification. I think back to just summarize what you said earlier about,
okay.
Working with the doctor, providing the appropriate accommodation, and then putting in the request, whether it's the GED or another testing service. Because in adult
right.
education, there are 3 different tests for the high school completion. There are 3
sure.
different approved tests.
Sure.
So I think each situation is going to be different.
Yeah, but Anne Marie, the thing is that the person was asking that the GED entity was basically imposing their will. In other words, their list of accommodations that they are willing to provide, and that is completely in violation of the ADA, if that's indeed what they're doing. Okay?
All right, so we are actually 1 minute after the hour, and everyone is
Wow.
everyone is still on with us. I've heard a few people roll off, so I want to see if there are any questions. We did go, because of time, we went through the section on undue hardship a little bit quickly because
Right.
you had covered that. You had covered that in part 2. But are there any other questions right now for Diego? Because you've all been wonderful. You have been holding on and listening for 90 minutes. So this is your time to ask other questions that you may have in the PowerPoint.
And if not, they can always write us afterwards, Yeah.
I do want to do a quick shout out while we're looking to see if there's any other questions briefly. That's our toll-free number up there and our email address and our website, shameless plug. It's southwestada.org. But if you call us, if you have additional questions, maybe something you didn't want to ask today, you can, feel free to call us and we'll help answer your questions. I posted a couple of links in there while Diego was talking. Those dealt with mainly service dogs. We do have a publication that we wrote that we provided in there. It's basically called Service Animals and Emotional Support Animals, where are they allowed and under what circumstances. So do check that out if you have more questions about that, because it pretty thoroughly explains the differences and in what instances they can be excluded, where they aren't allowed to go with the service animal, etc. So
that's right, yeah. And if you want to be more of a nerd of the ADA, an ADA nerd like myself, if you go to southwestada.org, our website, you can go directly to the Disability Law Index, where we have done the work for you and categorized all the regulations and statutes pertaining to different topics. So you can look under education, you can look under post-secondary, you can look under employment, Title III entities. You can look it up. It's all there under a topical index. If you want to see the actual law.
Oh, I'm sorry, Diego.
Yeah, no, that's okay.
And I just also wanted to let everybody know that I put the links in the chat pod again with the booklet that they wrote on service animals, as well as the Boots Law requiring for the service dogs, for the Texas law for the service dogs.
Thank you.
And I also want to just I want to take this opportunity before we close, since I don't see any other questions, and I know everyone needs to go on with their schedule today. But I do want to take this opportunity to thank Diego and Marissa. I've had the opportunity to work with both these fine individuals since before Christmas, and so I have learned so much. And if you do have time, I highly encourage you to go to their website, because that, in fact, is where this all started. I attended a session where the Southwest ADA Center was mentioned at a TWC conference in Houston over 2 years ago, and I went investigating and I found this website, and this is how this happened. So it is an amazing website with many, many resources, including an index of the actual ADA technical manual. So I want to say thank you to both of them, and thank you to all of you again for the incredible attendance with all 3 webinars. And as we close, just as a reminder, this PowerPoint for Part 3 will be loaded to the Adult Education and Literacy Community of Practice in the PD portal, hopefully in the next couple of days, if not sooner. And you will be able to receive your attendance, your certificate for attendance, by Monday afternoon. And again, let me know if someone was sitting with you that did not have audio. I've written down the people that have reached out to me. So thank you so much. And Diego, Marissa, I'll let you say the last words.
All right. Well, thank you for having us both here. I'll say that much. And thank you for listening to my voice. And again, give us a call if you have questions. I'll be happy to talk to you, to anyone out there directly. Just ask for me if you want to talk to me directly.
Thank you, everyone. We really enjoyed this. Hope you did too.
And we'll stay on the line for a few minutes just in case.